Welcome to Spoken Injustice, where we put the criminal justice system in the dock. The recent media coverage in relation to the Lucy Letby case and the allegations involving Russell Brand can only be described as a media feeding frenzy. These include both mainstream media as well as social media. But what are the facts behind it? In this video, we will examine the law on contempt and how this may apply to the Letby and Brand cases. So do follow us until the end as we provide you with tools to put you in a better position to reach a fair and impartial view. We do not give you opinions, we give you facts. On the 22nd of September 2023, in a press release, the Attorney General Office issued a media advisory notice in which it is reported that the Attorney General, Victoria Prentice KC, wishes to amplify the importance of not publishing any material where there is a risk that it could prejudice any potential criminal investigation or prosecution. Publishing this material could amount to contempt of court. The notice has been met with criticism from the press. The Metro said this advisory notice was criticized by outlets including The Times, which ran the initial investigation in collaboration with Channel 4's Dispatches and its sister paper, The Sunday Times. When debating contempt of court, several important and competing interests are to be placed on the scale of justice. Let's define these interests and how they may be balanced. Preservation of judicial authority, fair trial and due process, protection of witnesses and jurors, accountability and deterrence, public interest and transparency, freedom of expression are just a few that come to mind. They can all be traced back to two leading competing interests: open justice on one side and the proper functioning of the legal process, in other words, justice administration, on the other. There is no doubt that open justice is a central principle of criminal justice. On 21st of July 2023, an updated guidance on reporting restrictions in the criminal courts was issued on the judiciary website. It states, "It is a central principle of criminal justice that the court sits in public so that the proceedings can be observed by members of the public and reported by the media. Transparency improves the quality of justice, enhances public understanding of the process, and bolsters public confidence in the justice system." Media reporting is critical to all these public interest functions. The paper says there are occasions, however, when it is necessary to make an exception to these principles to protect the rights of children or the identities of some adult complainants, for example. But restrictions to open justice are not only limited to the protection of individuals' rights. They also applied for the protection of the general administration of justice and the proper functioning of the legal process. This is where contempt of court rules come into play. The law surrounding contempt of court in England and Wales is unsurprisingly complex and is regulated by common law as well as various statutes, and then, of course, case law. The main statute of reference in relation to contempt is the Contempt of Court Act 1981, which was enacted by Parliament following a ruling of the European Court of Human Rights that English contempt law was in breach of Article 10 of the European Convention on Human Rights, namely freedom of expression. We discussed this freedom in a previous video, albeit in a different context. If you've missed it, you can find it in the link in the description below. In June 2022, it was announced that the Ministry of Justice and the Attorney General's Office had asked the Law Commission to review the law on both criminal and civil contempt. In describing the issues, the Law Commission states that the development of the law of contempt has been unsystematic, resulting in a regime that is often disordered and unclear. Problems arise from the confusing distinction between civil and criminal contempt of court, the multiple ways in which contempt can be committed, and the overlap between the law of contempt and criminal offences relating to the administration of justice, such as perverting the course of justice. There are also growing concerns about the impact of social media and technological advancements on the administration of justice. A clear set of laws and rules would help, says the Law Commission, to ensure that the law of contempt operates as a principled, comprehensible and fair regime for all parties involved. The project is at its pre-consultation stage, and the Law Commission aims to publish a consultation paper this coming winter. This topic is no doubt one for a future video. However, in this video, we will attempt to give an overview of contempt of court as it stands today, and how it may apply to the most talked about cases in recent days, that of Lucy Letby and Russell Brand. But before we do that, here are my usual reminders. To leave a like if you're finding this video useful so far, and subscribe so that we may continue bringing to you the latest news surrounding the criminal justice system. Contempt of court refers to actions and behaviors that undermine the authority, integrity, and fairness of the court system. Contempt of court is not a criminal offence, even though it is punishable by imprisonment. The police and Crown Prosecution Service have no power to institute proceedings for contempt. Only the court has the authority to determine whether an action constitutes contempt, and the penalties can vary depending on the specific circumstances of the case. The court may impose a period of imprisonment, a fine, confiscation of assets, or other punishment permitted under the law. Incidents of contempt should in the first instance be dealt by a judge or the litigants themselves. The law officers, these are the Attorney General, the Solicitor General and the Advocate General, can also issue media advisory notices if they are concerned about widespread reporting which is taking place either in an apparent ignorance of a restriction on reporting, whether a specific order in a case, or if contrary to the strict liability rule as set out in the Contempt of Court Act 1981. They advised the media and the public that care should be taken when reporting the case to ensure they do not commit contempt of court. This can occur particularly in high-profile proceedings, such as those relating to alleged terrorist attacks. There are two main types of contempt: criminal contempt and civil contempt. Civil contempt typically involves a party's failure to comply with court orders or judgments, such as, for example, failing to pay child support, refusing to provide requested documents in a civil case, violating an injunction issued by the court, etc. Criminal contempt, on the other hand, involves actions that directly interfere with the ongoing proceedings, including actions aimed at disturbing court proceedings, such as shouting at court or the use of physical violence within a courtroom, but also disobeying a court order. Criminal contempt of court extends also to other actions, such as taking photographs, making recordings, or broadcasting from within the courtroom without permission, which may sometimes amount to criminal offences in their own right. Contempt also extends to publishing of information that could prejudice an ongoing trial, the so-called sub judice rule. Sub judice is Latin and means under judgment. It is important to note that this latter contempt does not affect accurate reporting of the status of a case or the issues it entails. It specifically refers to information that could prejudice court proceedings. For example, the disclosure of the accused's previous convictions, mere opinions on factual innocence or guilt of the accused, or any other information that would be generally withheld from the jury to ensure their impartiality. But what is the rationale behind publication contempt? The guidance on the government website states Contempt of Court Act 1981 states the publishing information that creates a substantial risk of serious prejudice or impediment to any active proceedings can be contempt of court. The Act applies to information shared through newspapers and television and radio, but it also applies to information shared in posts on social media, either by the media or by members of the public. This means that once somebody has been arrested, it is important to think very carefully about what it is shared online and ensure the care is taken not to share information that could prejudice or impede those proceedings. There is a danger that if jurors on that case hear about such information outside the court process, it could affect the way they think about a case or prejudice it so much that a trial cannot take place or has to be stopped. We have touched on these issues briefly in our video dedicated to juries, which you can find in the link below. However, having examined the interests at stake in detail, does any of this apply to the Letby case, in which court proceedings have concluded and therefore no longer sub judice, or to the Brand's allegations, in which court proceedings have not been instituted and therefore is not sub judice? let's examine each case in turn. Starting with the Letby case, in August 2023, Lucy Letby was found guilty of 7 counts of murder and 7 counts of attempted murder. She was found not guilty on 2 additional counts of attempted murder. There were a further 6 counts of attempted murder relating to 5 babies on which the jury was unable to reach verdicts. She was sentenced to life imprisonment with a whole life term. On 15th of September 2023, it was reported that Lucy Letby had formally lodged a bid to challenge her convictions at the Court of Appeal. On the 25th of September 2023, the CPS issued a statement as follows. We have sought a retrial on 1 count of attempted murder against Lucy Letby. There should be no reporting, commentary, or sharing of information online which could in any way prejudice these proceedings. As per the Russell Brand's allegations, on 15th of September 2023, Russell Brand shared a video on his social media denying what he described as very serious criminal allegations, the notice of which he said he received via letter and an email. On the 16th of September 2023, those allegations were revealed in an episode of the Channel 4 show Dispatches titled Russell Brand in Plain Sight, following a joint investigation by the Sunday Times, The Times, and the UK Current Affairs show Dispatches. On the 26th of September 2023, The Independent reported that the Metropolitan Police had launched an investigation into allegations made against Brand. In light of this, there is an argument that both cases could potentially be in the near future before a jury whose way of thinking about the case may have been affected by inaccurate information they have heard through media and social media, which could potentially cause prejudice. The prejudice may be so grave that could completely obliterate the prospect of a fair trial. Applying contempt law to prejudicial and inaccurate information, whether from members of the public or media who lack appropriate and direct knowledge of the case, is justifiable and appropriate. In fact, the criticism is that often this is not applied as it should. However, as always, there are some grey areas that may need to be looked at differently. Here are some questions which transcend the law and are to be taken only as points for discussion. For example, what should happen when the information published is accurate and reliable, but nonetheless capable of affecting or prejudicing pending proceedings? In the Letby case, for example, an online chain has emerged in which leading voices in the scientific community have expressed serious concerns about the evidence used in our trial. Should contempt law apply to reliable, genuine, and expert concerns raised in media, social media, in relation to apparent faulty and inaccurate evidence presented in an ongoing trial? Is there a scope for reform to allow a presiding judge to hear public concerns of this nature, when of course these are genuine and founded, rather than seeing through a trial which may lead to a factually innocent individual being convicted or a factually guilty individual being acquitted? Isn't this, after all, one of the purposes of the open justice principle, namely to improve the quality of justice, as rightly stressed in the judicial guidance we examined earlier? Let me know in the comments below. There is no doubt that balancing the competing interests we have examined here is not an easy task, especially when we equally value open justice and debate, as well as impartial and objective administration of justice. However, setting aside the legal aspect, from a human perspective, it is essential for each of us to exercise caution when commenting on ongoing legal cases, especially when we lack inside information. It will be a kind human gesture to empathize with those impacted and consider whether we would make similar comments if we were in their position. Isn't it more appropriate leaving any comments and debate to a time when the case has concluded and we may know more about the issues of the case? Let me know in the comments below. I hope you have found this video interesting, and if so, kindly show your support by hitting the like button and consider subscribing to join us at our discussion table. Also, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. Join us again next week. We look forward to usher you as we sit and rise in this unique trial.